Defendant, Briana Renee Mitchell, was already given a second chance through community supervision after a deadly case. But now, she's back in court facing multiple violations that could erase that opportunity completely. And once the judge starts asking those direct yes or no questions, you know the stakes are real. What makes this case even more intense is how quickly it escalates. New allegations include drug possession, giving false information, and evading arrest, all while already under court supervision. That is exactly the kind of pattern judges look at when deciding whether someone deserves leniency or prison. But there's another twist coming that—
Notice how fast those answers come. True. 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 That may sound simple, but legally, that is huge. By pleading true, she's not fighting the allegations anymore, she's admitting them. And in probation court, that shifts everything. The trial is basically over, and now the only question left is, how much time are you going to serve? That silence in the courtroom? That's the sound of consequences getting closer.
Many people miss. The defense is about to argue for years of jail credit tied to federal custody time, and that could dramatically affect how much time she actually serves. Then, just when the sentencing seems finished, the judge notices something major buried in the paperwork, an issue involving a deadly weapon finding that can change life after prison in a huge way. Watch closely, because this hearing becomes more than just sentencing. It turns into a lesson about second chances, accountability, and how every decision after conviction matters. And wait until you hear the judge's final words about parenting and humility, because that message hits harder than the sentence itself.
Are you the same Briana Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter? All right, did you understand by pleading true to violations 1, 1, and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
You're going to have to humble yourself. Right. Court is going to call 2020 CR 4098A, State of Texas versus Briana Renee Mitchell. Can I have parties announced for the record for the state?
Brittany Sparks.
Defense?
The attorney record, Monica Guerrero. I'm covering for Ms. Guerrero. Joseph Stateson. Ms. Mitchell, would you give this judge permission for me to do the plea in case of Monica Guerrero?
That's right.
All right. I'm going to need you to speak up, okay?
Yes.
All right. Are you Briana Mitchell?
Yes, ma'am.
All right. I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Briana Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter on December 10th, 2021 for a term of 10 years? Is that you?
Yes.
All right, state.
Yes, Judge. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Briana Renee Mitchell, committed the offense of possession of controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Briana Renee Mitchell, committed the offense of fail to ID fugitive intent to give false information in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Briana Renee Mitchell, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True.
We'll waive the other violations.
Any objections to the state's waivers?
None.
All right. Did you understand by pleading true to violations 1, 1, and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Notice how calmly those guilty pleas are entered. True, true, true. But in probation court, those short answers carry massive consequences. By pleading true to multiple violations, the defendant is essentially admitting the state can move forward with revocation. At that point, the courtroom focus shifts from proving misconduct to deciding punishment. And look at the range here, up to 10 years in prison. That's why judges carefully ask if the defendant understands the risks before accepting those pleas. It protects the record and confirms the decision is voluntary. The bigger question for viewers is this: if someone receives probation for a manslaughter case and then picks up new charges, should the court prioritize rehabilitation or public safety? Let me know in the comments, because that balance is exactly what this hearing is about.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
The court will find 1, 1, and 1 true. Is there an agreement?
Yes, Judge, we're asking that you grant the motion, revoke her probation, and sentence her to 10 years in TDC. In addition, Judge will be taking into consideration cause numbers 2022 CR 10345B, County Court cause number 692652, County Court cause number 692653.
Is that the agreement, defense?
It is, Your Honor, and I believe I may have made a clerical typo on the certificate of appeal. I may have put the case being TIC instead of the NPR. That's my mistake.
Yes. No, I'll correct that. Is there any objections to the court correcting that with the proper cause number?
None from the defense. And if I may put something else in the record, Your Honor.
Yes.
This offense was created during a time where Ms. Mitchell was on federal release, supervised release. She has federal back time, and post the offense, she did time in federal prison. I have some dates if I could put those on the record.
Yes.
She was in custody in federal prison or federal custody on April 18th, 2016, where she was sentenced November 17th, 2016. And she was not released until April 3rd, 2020. When she was released April 3rd, 2020, it was supervised release. And there was a revocation hearing. And she has federal custody time from February 18th, 2022 to April 13th, 2022. And we ask that she be given credit for federal time in addition to the Barry County time.
So you're asking for credit from April 18th, 2016 to April 13th, 2020?
We are, and I did explain to my client that is prior to the offense date, but she was still in custody post that also, and that it's the court's discretion to award time.
So with regards to the dates from April 18th, 2016 to April 13th, 2020, was this case open on a motion to revoke or no?
I don't believe it was on a motion to revoke.
All right, was this case pending?
I have to, I can check one moment, Your Honor.
Okay, so that's what I want to know about that. But with regards to the February 18th to 2020, February 18th, 2022 to April 13th, 2022, this was pending, correct?
Now, this is where the defense gets strategic. They're fighting for jail credit based on prior federal custody time. That may sound technical, but it can mean the difference between years served or years reduced. Time credit arguments are often some of the most important parts of sentencing, even if they sound procedural. The judge doesn't just rubber stamp it either. She starts asking smart questions. Was the case pending? Was there a motion to revoke? Was the defendant in custody for this case or another matter? Those details matter because credit usually depends on legal connection to the case being sentenced. This is a reminder that experienced judges look past emotion and focus on records, dates, and lawful calculations. Justice isn't only about punishment, it's also about accuracy.
Yes.
All right, so she will definitely receive credit for those dates. I just need to check on the April 18th date.
What are you gonna do?
Can you look for that too?
So that was the next one.
So when this case was on the system, what date was that again?
February 18th. And then she was running probation 12 10.
All right. Well, it appears, Ms. Sparks,
Yes, Judge.
on this case, I'm being informed by the clerk that this case was actually on the system January 2nd, 2016.
Yes, Judge, that's what our computer shows.
Okay, so we can go back on the record for now. So are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court is finding 1 and 1 true. The court will follow your agreement, revoke, sentence you to 10 years in the prison, take in consideration 2022 CR 10345B, County Court Cause number 692-652, 692-653, give you credit for any time served, and the court will give you the credit served in federal custody from April 18, 2016 to April 3rd, 2020, and February 18th, 2022 to April 13th, 2022.
Just when it seems over, the judge spots something critical: no affirmative deadly weapon finding on the record. That is a huge catch. Why? Because findings like that can affect parole eligibility, future consequences, and how the conviction is classified moving forward. The court reviews the indictment and discovers the death involved a discharged weapon. Even though there were questions about who physically possessed it, the charging language supports adding that finding. This shows why details in old case files still matter years later. Many viewers think sentencing ends once the prison term is announced. Not true. Sometimes the most impactful legal consequences are hidden in these final administrative moments. Always watch until the end in court. That's often where the real story appears.
Is there anything else from either side with regards to sentencing?
No, Judge.
Nothing from defense.
All right. For some reason, there's no affirmative finding on this of a
On the
deadly
original?
weapon. Yes. Let me see something, just one moment. I don't know what the underlying facts of this case were. Just give me 1 second. I'm assuming a weapon was involved, be it a vehicle or something else. All right, yeah, it's involved a gun.
It appears that my client appears that it was with the co-defendant who had a gun. Her client didn't have a gun, but that was not negotiated with the district attorney's office with Marcus prior to this.
All right, because I mean, according to the, and I know this is before your time, Mr. Statesman, but according to the indictment, it says that Briana Mitchell did recklessly cause the death of an individual, namely, the complainant, by discharging a deadly weapon. So this is pre this attorney, Ms. Mitchell, but that's what's in the paperwork. So there's going to be an affirmative finding. So there's an affirmative finding of a deadly weapon. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck. We can go off the record. I saw in this case where parenting classes were ordered for you. So here's the thing. Someone else is taking care of your children or your child. When you are released from prison, and at some point you will be, do not go up to the house acting as though, here I am, let me put my rules in place and disregard whatever rules have been set for your children. You understand? You're going to have to humble yourself. All right, good luck to you.
This case ended with probation revoked, a 10-year prison sentence imposed, and additional custody credit granted for prior federal time. But beyond the legal ruling, the judge delivered something even more personal: a warning about returning home with humility after incarceration, especially when others have been raising the defendant's children. That final message speaks to a bigger truth. Court cases don't end when the gavel drops. Families are affected, children are affected, futures are affected, and when someone is given a second chance, what they do next can determine everything. The courtroom here balanced accountability, procedure, and reality. A serious prior offense, repeated violations, and lost trust ultimately led to prison. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you, Judge.
Thank you.
Checking in on